I am Professor Angela Upchurch, and this video, a primer on the litigation process, is designed to help you as a tort student read and understand cases with an eye towards the litigation process. In other words, it's a basic on what happens during the course of a lawsuit. One thing you need to understand is that your casebook is comprised of a lot of appellate court decisions, and that's true not only in torts, but in most of your first-year classes. An appellate court decision is really reviewing the trial court and any lower appellate courts beneath the appellate court that you're reading, their decisions in the case. And so often, like in torts, what we're really trying to do is understand the law at the basic trial level, but we're looking at it through the lens of the appellate court judge, who basically is critiquing, reviewing the decisions that the trial judge made below. So what you need to think about and ask yourself when you're reading these appellate court decisions in terms of process is first, at what point in the trial lawsuit, where are we when the decision was made that this appellate court is now reviewing? All right, were they early in the litigation process, partway through, after, or at trial? The next thing you want to ask yourself is what information was before this trial judge? If they're very early in the litigation process, they may not have any evidence in front of them. They may just be looking at the parties' papers. Thirdly, you want to ask yourself what happens if the appellate court reverses the trial judge? What's going to happen to this case? Is judgment going to be entered for the opposing party? Is new trial going to be ordered? Do we continue where we were? So let's take a little look at the litigation process and think of it as a timeline. When a party is injured, like in the case of torts, and seeks to sue the party that wronged them, typically what they're suing for is damages, and that's what we're going to kind of work on when we think about this litigation timeline. And so I've simplified this tremendously. You'll learn a lot more about this in civil procedure, but just to give you some context so when you're reading these decisions, you understand what's going on. So let's say that injured party would like to go to court. Well, the first phase in litigation is the pleadings phase, and you want to think of this as the way to get through the doors to the court. Right, so what you do as a plaintiff party is you file a complaint. It's basically your papers that set forth the claims you are bringing against any opposing parties or defendants that you're bringing in your lawsuit. So let's say you were injured in a car accident. You as the plaintiff, the injured party, brings a suit against the driver of the other car as the defendant, and in your complaint you assert the tort claims that you want to bring against that driver. The opposing party, the driver, the defendant, also gets the opportunity to put their papers before the court, and that is an answer. There are more than just the complaint and answer that form the pleadings, but that's the basics. They get the opportunity to assert any claims they have against the injured party. They also have the opportunity to assert any defenses they have to the claims that are brought against them. So this is very early in the process, and what you're looking at is the parties' papers before the court, the way to get into the court and explain what this lawsuit is really about to the trial judge. The next large phase of the litigation process is discovery. And in a nutshell, discovery is really where the parties learn more about the lawsuit. So they exchange a great deal of information in the form of records and files. Medical exams can happen at this point in time. They get to identify potential witnesses that they might call at trial, and they get to interview these people to learn what they know about the lawsuit's claims and defenses. They might modify some of the pleadings they filed in court earlier based on what they learn in discovery. This is a big chunk of the time of litigation, and a lot of it is its expenses as well. After discovery is completed, the case goes to trial. This is what you often see in TV representations of litigation. This is where the party gets to make their opening statements before the jury. They get to put on their evidence. They get to cross-examine and examine witnesses. They make objections to evidence. They make their closing statement. Then the judge instructs the jury on the law, and the jury deliberates and reaches a verdict. Right after that, we get a judgment. This the judge enters. It's for the winning party after the trial. At this point, the parties can then use that judgment and execute it against the other side, turn it into money damages, for example. They also can appeal this judgment, and in the cases in your casebook, that's what occurred. They are appealing either a judgment that a judgment was entered at the end of a full trial or a judgment that was entered before a full trial. So let's talk about that for a moment. This is sort of a very generic look at the litigation process timeline. Like I said, you'll learn more nuances to it in civil procedure, but ultimately, a lot of what you're reading in your case books is reaching that judgment, and you can reach it through the full process after a full trial and a jury verdict. You can also find ways to shortcut it, and that is known as our motions practice. So if we look at the same timeline, what we're going to do is highlight some of the motions that you'll see in the litigation process, and these are often what you're reading in the appellate decision is the review of a determination of a judgment entered after a motion was made. So the earliest motion that we can make is a motion to dismiss. It's known by different names in some state systems, motions to demur. Basically, these early motions are looking at the pleadings alone. Remember, that's how we got into the court. It's the papers we filed. And what the party is seeking to have done at this point is for the judge just to look at those papers, the claims, the defenses, what we've asserted, and say, based on what we've asserted, I'm entitled to judgment. So basically, end run the whole process and get to my judgment now. Sometimes we'll read appellate decisions in which a motion to dismiss has been granted, and the appellate court is considering that trial judge's decision and realize in that kind of a case, this decision was made very early in the litigation and is dealing with the parties' papers, not witnesses, not a trial, not even information obtained during discovery. The next time we see motions is in discovery, and a lot of motions are filed during discovery, or this is a common time to see this motion. It's the motion for summary judgment. This motion, we'll read several opinions in your casebook over this semester that were grants of motions for summary judgment. And basically what this is another attempt for a party to get an early judgment from the court to now only leapfrog around the trial process. And what the party's asking the judge to do is say, look at all the information we've obtained during discovery. Here's the records, here's their affidavits, here's the deposition testimony I took from these individuals who will come to testify in court should we have a trial. And look at what they're going to tell you. They've already said it under oath. You don't need to go to trial. Just look at what we've uncovered here and grant me a judgment in my favor. The next series of motions that we'll see are ones made during trial. One common one is the motion for judgment as a matter of law. It also has other names in different state systems. This one is where you're in the middle of trial and the opposing party has rested and you're asking the judge to say, look, you just saw that witness and all the opposing party's witnesses testify. Based on what they've said on the stand here at trial, there's no reason the jury needs to deliberate here. It's clear, there's no question. Basically, I should be awarded a judgment. And it's more nuanced than that, but that's a good kind of a rough way to think about it. And so you're basically getting around the deliberation process at this point to get to your judgment. There are some motions that happen after trial, and they're post-trial motions. Two main ones that you'll want to know about as you read the appellate decisions in your torts casebook this semester. And the main one first is a motion for judgment as a matter of law. This one is just like the one you saw during trial. Basically what the party's asking for this one is a judgment in their favor. Basically, notwithstanding whatever the verdict is from the jury, I should be given judgment as a matter of law. The reason I have a little the no symbol here is they're not asking for a new trial. They're really just asking for a judgment to be entered in their favor. The other motion, by contrast, is a new trial motion. This one is asking the judge to basically allow a redo of the trial and to send the case back to the beginning of trial with a new jury to reconsider the evidence and render a new verdict. One last point of information before we close up this video is something to think about, which is the different roles a judge has versus a jury. All right, so we're going to think about the judge's role here for a moment in their role as a judge and not as a trier of fact. The judge generally is basically the umpire in the room. They rule on matters of law. They make the decisions on motions and on objections that are raised by the parties. They decide legal questions. They supervise the pleadings process and discovery. They also supervise trial by ruling on objections and giving the jury their instructions. And ultimately, they enter the judgment at the end of trial or on a motion should they choose to grant it. They also can wear the hat of the trier of fact, and so there are times when a judge has to play two different roles. What I have summarized here is their role as a judge in that role and not really as the trier of fact. Sometimes they jump over and play the trier of fact role, which is the one that the jury plays in a jury trial. But if you have a bench trial, the judge also plays that fact finder role. So what is the fact finder role or the jury's role? Well, it's a role that happens at trial, only at trial, and they decide the facts that are before them, and they apply the law to the facts as directed by the judge through the jury instructions. They determine the credibility of witnesses, and they weigh the evidence. And ultimately, with the jury's instructions that are given to them by the judge, they deliberate and render a verdict. And we'll talk more about this as the semester continues, and you'll of course deal with this in more detail and with all of the nuance when you get to civil procedure. But hopefully this provides you a little bit of context as you're thinking about and reading the torts decisions in your casebook this semester.